Copyright law, as I'm sure you all know, provides that you have to establish two things. Number one, access. In the idea theft claims, you have pretty much admitted access. And number two, substantial similarity. In the summer of 2010, the Ninth Circuit came down with a case called Benet versus Warner Brothers. And I read this case, and it seemed like the similarities were just absolutely overwhelming. The name of the screenplay that was pitched was called The Last Samurai. The movie was called The Last Samurai. It used characters, plot lines. It even had the same historical mistakes in it as the screenplay. The access was undisputed. Yet the Ninth Circuit still concluded that there was not enough substantial similarity for a copyright infringement claim. After reading that case, I began to wonder whether or not anybody ever wins these copyright infringement cases, at least in the case of a screenplay or a treatment. So I had my summer interns in summer of 2010, one of whom's here, Danny Lifshitz. Say hi, Danny. Look in every case that they could possibly find over the last 20 years for copyright infringement against a studio involving a screenplay or a treatment. And they basically found approximately 50 cases at that point. And what was interesting is that no plaintiff had ever won. As we looked into it, it appeared that the cases were wrong. They were incorrectly reasoned, and I'm going to explain that in a second. And number two is, how do you win these cases? How can you possibly win a copyright infringement case? The cases such as Funky Films, Benet, they're applying something called the filtration test. The filtration test basically says we're going to screen out all the unprotectable elements before we even do the analysis. Now, when they're talking about unprotectable elements, they're talking about ideas, they're talking about characters. Characters aren't copyrightable unless they're animated characters. They're talking about plot lines, they're talking about scenes of fare. So when they finish screening out all these unprotectable elements, there's never anything left. The real test, the one that they should be applying, and the one that's been approved by the United States Supreme Court in the Feast Publications case in 1991, is what's called the selection and arrangement test. The selection and arrangement test basically says, no, we're not going to filter anything out. We're going to look and see if there's a copyrightable combination of non-protectable elements. So we're going to include everything. We're going to include the characters. We're going to include the plot lines. We're going to include everything. And then we're going to look at it and we're going to say, does this form a whole that's copyrightable in and of itself? And if so, has that been infringed, that copyrightable whole which includes non-protectable elements? So what has happened now is essentially the courts break the work into individual elements, and then they find that each element is individually non-copyrightable, and then there's never anything ever left to constitute anything that's protectable, and the defendants always win. It's not just one idea or similarity. It's a lot of ideas and a lot of similarities. And what happens is the author who, in my opinion, infringes, he always puts his own stuff in. He doesn't just copy the other author verbatim. He adds to it because he considers himself a writer, of course, too. And so he adds to it and he subtracts from it and he changes things a little here and there. That's the easiest thing in the world to do. And that's why the test was originally you don't look at dissimilarities. And the reason for that is because I believe it's Learned Hand who said, talking about Learned Hand, a plagiarist does not excuse his wrongful conduct by adding to the work, by adding his own work to the previous work. So that's why you only look at the similarities, because you know a plagiarist is going to add his own stuff as well. If you can line up your similarities identically with Shaw versus Lindheim or Metcalf versus Bochco, I mean qualitatively, quantitatively, if you can line them up exactly, then you should get past at least a motion for summary judgment on the issue of substantial similarity. Another thing that we haven't tried yet, but it seems like a good idea, would be to have a Writers Guild arbitrator as an expert witness. I'm not arguing for there to be some test where two people come up with the same idea for a cop show about dirty cops or whatever, and that would be enough for copyright infringement by any means. What I'm saying is look at everything. Look at the ideas. Apply the selection and arrangement test, which Feast Publications, a United States Supreme Court case, said that that's what should be applied. Metcalf said that that's what should be applied. Apply the selection and arrangement test. Look at the totality of the similarities between the two. And then if the totality of the similarities between the two is substantial in either a qualitative and or quantitative way, then that's copyright infringement. And that's the way it should be, because otherwise no one is ever going to win one of these cases. I guarantee we'll be back at this another 20 years from now, and we will have another 50 cases that the plaintiffs lost. Because it's impossible to win when you separate out each element and then attack each element separately. It's like shooting fish in a barrel.